Good morning, ladies and gentlemen. This is Kunal here. Today we are going to read the chapter Directive Principles of State Policy. Let's start. Chapter at a glance. This chapter introduces you about directive principles which are mentioned in part 4 from Article 36 to Article 51 of the Indian Constitution. These principles are meant for the state to follow them in the matters of administration and in making of laws, because the basic aim behind this principle is to establish a welfare state. These principles are fundamental in the governance of the country. One of the distinctive features of Indian Constitution is the inclusion of the directive principles of state policy. Borrowed from the Irish Constitution, the makers of our Indian Constitution incorporated these principles in Part 4 of the Constitution from Article 36 to Article 51. The directive principles are some affirmative instructions to the state authorities to secure to all citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and opportunity, to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. These principles underline the philosophy of democratic socialism to secure the high ideal set forth in the preamble to the Constitution. It is the duty of the state to follow these principles both in the matters of administration as well as in the making of laws, because the basic aim of the directive principles is to establish a welfare state where economic and social democracy might flourish. The directive principle of state policy may be classified into four categories. First, economic and social principles. Directive based on Gandhian principles. Directive principles relating to international peace. Miscellaneous principles. These principles are different from fundamental rights. While fundamental rights are enforceable, directive principles are not enforceable by the court. The courts cannot compel the government to follow these principles, but it is the duty of every responsible government to translate these principles into actions to promote social and economic justice among citizens. Fundamental rights are negative or prohibitive in nature because they put limitations on the state. On the contrary, directive principles are affirmative directions. They declare the duty of the state to achieve certain social and economical objectives. Although the directive principles and the fundamental rights appear in the Constitution as distinct entities, there is a close relationship between the fundamental rights and directive principles of state policy. They are complementary and supplementary to each other. Both are required to realize the goals and ideals declared in the principle of the Constitution. The central theme of directive principles is human development with distributive justice, aim at upward movement of the entire social system by making more people better off without making others worse off. The interrelationship between the two results is greater freedom and the autonomy of all people, reduction of disparity in access to resources and opportunity, and sustainability of environment. From 1950 onwards, various programs have been implemented to give effect to the directive principles. Some of them may identified as follows. First, the Minimum Wages Act 1948, Child Labour Prohibition and Regulation Act 1986, etc. seeks to protect the interests of the worker. Second, Maternity Benefit Act 1961 and Equal Remuneration Act 1976 have been implemented to protect the interests of women workers. Third, Handloom Board, Handcrafted Board, Core Board, Silk Board have been set up for the development of the cottage industries. Integrated Rural Development Programs, Jawahar Rozgar Yojana, Swarna Jayanti Gram Swarozgar Yojana, 1999, Sampurna Gram Yozgar Yojana, 2001, Mahatma Gandhi National Rural Employment Guarantee Program, 2006, etc. have been implemented to improve the living standards of the people. The National Forest Policy 1988 aims at the protection, conversion and the development of forest. There are several other enchantments by the central and the state government to give effect to these principles. In spite of the above steps by the central and the state government, the directive principle of state policy have been implemented fully due to the lack of resources, social, economic conditions and population. Some of the terminal questions are: first, describe the directive principles of state policy. Are they justiciable? First, the directive principles of the state policy contained in Part 4 from Article 36 to Article 51 of the Indian Constitution constitute the most interesting and the enchanting part of the Constitution. The directive principles may be said to contain the philosophy of the Constitution. The idea of directive being included in the Constitution was borrowed from the Constitution of Ireland. As the very term directives indicate, the directive principles are broad directives given to the state in accordance with the legislative and executive powers of the state are to be exercised. The directive principles are non-justiciable in nature because they are not legally enforced by the courts for their violation. Therefore, the government cannot be compelled to implement them. They were made non-justiciable because they tried to establish economic and social democracy in the country. So, to implement them, lots of resources were required, which India did not have at the time of independence. With time, directive principles can be made justiciable or converted to fundamental rights like the right to education, which was made a fundamental right in 2002. Earlier, it was a directive principle. Second question, classify the directive principles of state policy. First, the directive principles of may be classified into four broad categories. First, economic and social principles. Maximum number of directive principles are socialistic in nature. These are directed to achieve social and economic welfare of the people, whose main aim is to establish India as a welfare state. Second, directive based on Gandhian principles. Mahatma Gandhi played an influential role regarding the independence of India. He was the main guiding force during our freedom struggle. He made large influence on the common people as well as on the framers of the Constitution. There are certain directive principles complemented on the basis of Gandhian principles. Third, directive principles relating to the international peace. The members of the Constituent Assembly were deeply concerned about the international peace and security. With the help of directive principles of state policy, they tried to ensure that government of free India should render active cooperation for world peace and security. Miscellaneous principles. The fourth category of directive principles contains some general subjects which are sometimes termed as liberal principles. Question 3. State any four directive principles aiming at socio-economic equality. The four directive principles aiming at socio-economic equality are as follows. First, Article 38, to secure a social order for the promotion of welfare of the people. Article 39b, ownership and control of material resources of the community shall be so distributed so as to subserve the common good. Third, Article 42, provisions of just and humane conditions for work and maternity relief. Article 43a, participation of workers in the management of the industries. Question 4. Describe directive principles based on Gandhian thought and principles. Gandhi had a remarkable impact on the framer of the Constitution. So, some directive principles were inspired from Gandhian thought. Under these directives are the guidelines for organizing village panchayat, prohibition and intoxication of drinks and cow slaughters, secure living wages, decent standard of living, and to promote cottage industries, to provide free and compulsory education to all children up to 14 years of age, etc. Article 40, organization of village panchayat. Article 43, to promote cottage industry. Article 46, promotion of educational and economic interest of the SC and the ST and the other weaker section of the society. Article 47, to bring out the prohibition of intoxication drinks and drugs that are injurious to health. Article 48, organizations of culture and animals husbandry on modern and scientific lines to prohibit the slaughter cows, claves and other milch and draught animals. Question number 5. Distinguish between the fundamental rights and the directive principles of state policy. Answer. The difference between fundamental rights and the directive principles of state policy are significant. The differences are discussed below. Fundamental rights are injunctions to prohibit the government from doing certain things. The directive principles are affirmative instructions to the government to do certain things. The directives are non-judicial. Courts do not enforce them. Fundamental rights, on the other hand, are justiciable. They impose legal obligations on the state as well as on the individuals. Courts enforce them. If a law violates a fundamental right, the law in question will be declared void. But no law will be declared unconstitutional on the ground that it violates directive principles against violation of the fundamental right. Fundamental rights establish liberal political democracy in India. However, directive principles make India a welfare state. Fundamental rights protected the interest of the individual, while directive principles of state policy seek to promote socio-economic equality and particularly provide safeguards to weaker and the vulnerable sections of the society. Successive government. Question number 6. Successive government in India accorded high priority to directive principles of state policy. Do you agree with the statement? Give suitable arguments to support your answer. Answer. Considering the various decisions of the Supreme Court regarding the primacy of the fundamental rights and the directive principles of state policy, at present the fundamental rights enjoy the supremacy over the directive principles. However, this does not imply that directive principles cannot be implemented. It was a view of Jawaharlal Nehru that where there was a conflict between the fundamental rights and the directive principles of the directive principles of state policy should prevail. However, where we look into the judicial nature of the above two, we saw that Supreme Court should uphold the fundamental rights because they were guaranteed by the Constitution and justiciable. But the solution provided by the Supreme Court may be judicial and not practical in all cases. It is the Parliament which was reached beyond the judicial solution. When a social conflict arises out of the conflict of the fundamental rights and directive principles of the state policy, the state should emerge as a torchbearer because ultimately it is the superiority of the social interest over the individual interest. However, it is a duty of the court to resolve a conflict with an eye of the constitution with the other of the social harmony. After the Minerva Mill case, the Supreme Court to the view that there is no conflict between the fundamental rights and the directive principle of state policy and they were complementary of each other. There was no need to sacrifice one for the cases of the other. If there is a conflict, it should be avoided so far as possible. Question number 7. What steps have been taken by the government so far to implement directive principles of state policy? The Constitution framers enshrined so many principles in order to establish a new social order in which social justice, economic and political shall prevail. To ensure minimum basic necessities of citizen is civilized society and to establish a democratic setup, rest of social justice. The constitution framers adopted peaceful and evolutionary method followed by the constitutional reform. To fulfill the basic objectives, the state has been charged to make effective provisions for securing the right to work, to education and to the public assistance in case of unemployment, old age, sickness and disablement and in other cases of undeserved want. Article 41. To implement and translate such directives into action, the government has taken so many steps colored by these directive principles. The government has enacted social, labor and economic legislation besides industrial, agricultural and taxation policies. For example, the Taxation Inquiry Commission 1953-1954 was asked to examine the tax structure and to suggest measures to reduce the inequalities of income and wealth and some other related subjects. The Industrial Development and Regulation Act 1954 and the establishment of the Monopolies Inquiry Commission in 1965 were aimed to achieve the objective outlined by the Taxation Inquiry Commission. The Monopolies Commission made prohibiting inquiries into the cause and the extent of concentration of economic power in private hands, the factors responsible for monopolies' tendencies in the national economy and their social consequences. Similarly, in the early years of the 1950s, land reforms legislation was enacted to abolish intermediaries and zamindari system, and now land, both rural and urban, is subject to ceiling and the surplus land has gone to the weaker section of the community. In compliance with such laws, such states has enacted separate state act to prevent the concentration of land holding and fixed a ceiling for an individual owner. A large number of laws have been enacted to implement the organization of village panchayat as a unit of self-government. Article 40 all over the country and especially the government has enacted the historic 73rd and 74th Constitutional Amendment Act 1992 to build Panchayati Raj institution as an administrative unit. Now panchayats have been assigned 29 departments with full power so that people of villages can fulfill their long-standing dreams by their sufficient support and participation. Most of the states has enacted their own states panchayat act with some spirit of the main act and developed funds, functions and functionaries to make panchayat as an institution of self-government. For the promotion of cottage industries, Article 43, steps have been taken to encourage the masses. Various measures, including the employment generation schemes, have been undertaken to promote and uplift the SC, ST, and the other backward classes. Legislation for compulsory primary education, Article 45, has been enacted. For raising the standards of living, Article 47, the Government of India adopted the first ever large scale program called Community Development Project in 1952 for rural reconstruction in the field of the communication, transport, housing facilities, sanitation, agriculture, education, etc. Regarding prohibition of intoxication, drinks and drugs, Article 47, most of the states has enacted legislation and imposes some restrictions on it. Necessary legislation has been enacted to protect places and monuments of national importance. As to the separation of the executive from the judiciary, Article 50, most of the states have been taken legislative measures. Steps have been taken to assist and give free legal aid to needy village people. Lastly, the Government of India has enacted the National Rural Employment Guarantee Act NREGA to ensure 100 days work assistance to rural people, which is conformity to the right to work enshrined in Directive Principles of State Policy of the Indian Constitution. Question number 8. In a poor country like India, socio-economic justice should be given priority over the individual freedom. Do you agree with the statement? Justify your answer with the suitable arguments. The Constitution of India has solemnly promised to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among the all fraternity, assuring the dignity of the individual and the unity of the nation. The Constitution has attempted to attune the apparently conflicting claims of socio-economic justice and of social liberty and the fundamental rights by putting some relevant provisions. The scheme of the Constitution for the realization of the socio-economic agendas compromise for both of the justiciable fundamental rights as well as the non-justiciable directive principles. The judicial contribution to the synthesis and the integration of the fundamental rights and the directive principle is the process of constitutionalization. Social and the economic rights have been crucial to the realization of the directive principles, not only a means to effective fundamental rights but only as a source of laws for a welfare state. It is a well recognized fact that for the sustenance of political democracy established by fundamental rights, socio-economic equality and welfare state is essential. Thank you and thank you so much. Namaste.